Welcome back to the Law News Network. I'm Ron Blitzer. We have an unexpected 1-hour recess in the Toledo murder trial. The prosecution was getting ready to, and they actually began playing police interview of Toledo the day that the victims in the case were reported missing. And there were some discrepancies between what was expected to be played and what was actually played. The prosecution and the defense had made arrangements for which portions of the recording would be redacted, and they had each made their wishes known, and they had reached what appeared to be a mutual agreement on the matter. But once the video began playing in court, it didn't go according to plan. So the defense was objecting to that. We couldn't really hear what the defense attorney was saying. He wasn't speaking close to the microphone, but the gist of it was that there were parts of the recording that were not supposed to be played, apparently, that ended up being played. And now the judge called for a 1-hour recess in order for everyone to sort this whole thing out. With me right now is attorney Jonna Spillbor. So have you encountered anything like this before with, whether it's a recording or other piece of evidence that was supposed to be redacted a certain way that wasn't?
Well, I can say this whole scenario is weird in so many ways. Let's take it from the top. Number one, typically when a defendant gives any sort of recorded interview, the whole shebang comes in. Like, there really is no reason, if you think about it, to redact anything, because all that can be used against you. That's why police tell you, anything you say can and will be used against you. They're not lying. That happens. So why pre-trial did anything, was anything agreed upon to be redacted is strange. I would like to get the backstory on that. Number two, we were listening to the interview, and nothing that was objected to was earth-shattering. He's talking about he said the word lesbian 3 times. Like, what does that have to do with anything? Like, so it wasn't like he said, yeah, I killed her in the living room with the knife. It was just sort of inane conversation, yet it was being objected to. Number 3, what the jury didn't hear is the counsel went through this with the judge before the jury was sat this morning. Everything seemed fine. So now you have to ask yourself, is this just a tactic to slow things down by the defense attorney? Because like I said, we were listening to the same interview. He didn't say anything yet that was particularly, earth-shattering. So what's up?
Yeah, no, that's a very interesting point. You're about to hear this interview where there could be earth-shattering statements made, but now this whole process is being drawn out. The jury is going to be getting bored waiting for an hour. They don't know what's going on. Breaks the momentum. And while they were waiting to hear something and sort of getting into the flow of this conversation, now that's halted. Now they're going to be wondering what the issue is, what's being taken out. They're going to be thinking about other issues going on with this recording. So when this starts playing up again, maybe their attention won't be 100% where it should be. Who knows? And
look at it this way. If you're a juror, now put your juror hat on. First of all, you're not just listening to this defendant's words, you're looking at his body language. He's leaned back, he has his arms crossed in front of him, kind of weird. The second thing I noticed is this interrogator, it's not a murder investigation yet. It's a missing person investigation, although we all know it was a murder investigation. And he's asking this defendant for his help. He's trying to befriend him. I need you on my side. We got to figure out what happened to your wife and her children, even though you treat them like your children. All ruse. And I think if I'm sitting in the jury box and you're giving me an interrogation, but you're cutting pieces out, that's annoying. Like, I'm going to be trying to fill those pieces in my mind, and I don't know if that's going to work for either side in this case.
No, certainly not. It's not a good thing when the juror is trying to imagine something that's not part of the evidence, because, as you said, it could hurt one side or the other one. You don't know, but they're not paying attention as much to the actual evidence, and that could be problematic. But it is an interesting point that you make about Toledo and his demeanor. He's being told this is a missing persons case right now. They're asking for help. At the same time, he was already arrested for a domestic violence incident the day before.
Right.
So what's interesting there is, he knows that he was already in trouble for the domestic violence, but now they're trying to work with him, which I think is a very interesting, a very good tactic by the sheriff's officer, Sergeant Pagliari. So kind of maybe lulling Toledo into a false sense of security. Oh, I'm already in trouble for this, but they don't suspect me for the big one. So he's just going to keep talking. As a prosecutor years ago, I interviewed many domestic violence defendants, and you'd be surprised how forthcoming a lot of them will be, and to try to give their side of the story and talk, not realizing that they're damaging their own case in the process.
Oh, usually, yeah. They think that they don't realize that they are. They think they're being helpful to themselves. See, that's it. They're not trying to be helpful to the prosecution. They're trying to help themselves. And in this case, it was also interesting because he's in an orange jumpsuit, so he's in custody on something, and the interrogator says to him, you don't have to talk to me. You're free to leave. Well, he's really not free to leave. He's in a jail situation. But what the interrogator is trying to establish there is that it's a voluntary, if there's going to be a confession, it will be a voluntary one. And that's a really key evidentiary point that this interrogator was trying to establish here. But we don't know where this interview is going because it's been cut off 11 pages in.
Yeah, and there have been a lot of issues regarding statements that Toledo made, and these statements that are supposed to be brought before the jury here. And yesterday, the defense was trying to keep any of it from getting to the jury. The judge rules against them. They're trying to argue that the prosecution hasn't even made a case for murder. They said, oh, you've proved that a death occurred, but not a murder. The judge didn't buy that at all, because we've heard already plenty of evidence. We're actually going to show you a clip soon of some testimony from DNA analyst Anthony Gargone. He testified in court yesterday about DNA analysis that he performed that showed blood on several items that matched Talia Otto, who is the daughter
and the children
of Yesenia Suarez. And we heard from the little bit of the interview here that Toledo considered Talia and the other child, Michael Otto, to be like his kids, even though he's not the biological father. So we're going to show you part of that testimony from